Thank you, Chairman, and thank you, Director. Director, as you are aware, the Department of Healthcare Finance has decided not to submit the state plan amendment for Medicaid reimbursement of home visiting programs as required in my Home Visiting Reimbursement Act of 2023, which was funded in the FY25 budget after significant work from my office and the Health Committee. Frankly, it's exasperating and I consider irresponsible that the Department of Healthcare Finance has made this decision despite the passage of the law, dedicated funding, and a history of council-directed changes to state plan amendments. Why is DHCF ignoring the law and refusing to submit the home visiting state plan amendment?
I don't agree with your characterization that we are being irresponsible. We are following the law based on the advice of two different attorney generals. Their advice is that when the council passes a bill that directs the mayor to change the state plan, that bill is legally insufficient, and that if the mayor agrees, she can direct us not to execute that SPA amendment. So in order to get a request to change the state plan to be considered on its merits, the language has to be constructed in a way that does not abrogate the mayor's authority as the executive officer and the sole person with the authority to modify the state plan.
Director, has the Department of Healthcare Finance submitted state plan amendments in the past as a result of laws passed by the council?
Yes, and we were told by the Attorney General, and that we have also not submitted SPAs based on similar language, but we were told by the Attorney General's office that if we continue to enact state plan amendments based on language that is legally insufficient, that we run the risk, should that issue ever go to court, of weakening the executive's position that she is, in this case, the sole person who has the authority to amend the state plan. And so based on that advice, we decided, as my job, to notify the mayor that this language does not meet the requirements of law, and we were told that we could stand down on the SPA amendment.
So it was okay to do it before, but it's not okay to do it now.
No, that's not what I said. What I said was, we have done it in the past, unaware of the fact that our agreeing to do it reduces potentially the mayor's authority to as the sole person responsible for changing the state plan. Once we fully understand that, and we got the advice from a second attorney general, then I told my staff to make sure that whenever a bill is passed, we make sure the language is legally sufficient. And if it's not, then I need to notify the city administrator and the mayor that this is the bill that was passed. It is directing the mayor to do something that the council does not have the authority to do. And then she can decide whether or not she wants to go forward. But if you go forward, you potentially weaken your authority as the sole person responsible for amending the state plan in the district. And I would add, this is an authority that no other governor has. It's a valuable authority. And the mayor, rightfully, in my mind, in my judgment, decided that she was going to protect that authority.
Yes, well, we're all very aware of the way she likes to protect her authority, regardless of what's at issue here. But as we heard in public,
She's the mayor of the city.
Yes, she is.
Her job
and
is to
she
execute.
regularly flouts our.
And her
She
job is to
regularly chooses not to implement the laws passed by the legislative body, which is the lawmaking body in the District of Columbia. As we heard in public,
I can only speak to this instance. I don't know what other issues you're referring to, but she responded in this way because I sent a notice to the city administrator and the policy director saying that this language is violative of the charter, and the OAG has opined, and I recommended that we not go forward.
And why at this juncture, given how much dialogue this committee has had regarding this particular law, there was an extensive conversation in last year's budget hearing about the fiscal impact statement, the options to reduce the first year cost in order to get it funded. And this never came up until after we set the money aside for the program.
That's not an accurate statement. We've had this discussion before, and I have pointed out that this language is important to the mayor. And I assume it would not be important to the council because all it means is changing the language from shall to a may. But apparently it is important to the council. So I think the legitimate question is, Why is that language important to the council when they can get any bill considered on its merits involving amending the state plan by simply saying the mayor may consider blah, whatever the amendment is?
Well, frankly, I think that's ridiculous because what you're
Well,
effectively saying, please let me finish. What you're effectively saying is that because we are directing her instead of asking her, she's refusing to do it
No, that's
on
not what I'm saying.
principle.
What I'm saying is she's following the law based on the advice of two separate.
We make the law.
Well, then if you want that law changed, then you should do so.
Sir, as we heard in public testimony last week, the delay in implementation has put these critical programs at risk. Research shows supporting new mothers and mothers of young children has short and long-term impacts that help families providing a nurturing and healthy environment for their kids. And your own pre-hearing responses catalog the success of the Nurse Family Partnership, one of our home visiting programs here in the district. How are we going to expand this program if you're not going to move forward with the SPA?
Well, there are two issues there. You can get the bill considered on its merits by simply changing the language, and then the bill can be evaluated for its fiscal impact. And if the mayor agrees with both the substance of the bill and concludes that the fiscal impact is not onerous, then she will sign it. That's how you move forward.
Oh, I don't believe that for a minute.
Well, that's your prerogative. I'm just telling you how a bill moves forward in this case.
I am familiar with
Now,
how
she has the right to say that if the bill comes before her and the fiscal impact is something that she doesn't think the district can handle in this over the next 4 years of the operational plan, she has the right to say, I'm not going to sign it.
Well,
Then
we
you don't have-
funded that though. You're a couple steps behind.
You funded the bill, but my understanding is when you look at over the operational plan, there's additional costs. Now, it may well be those costs are sustainable, but you have to consider the fact that we're about to enter a fiscal year where the latest financial information shows that the citywide has only $40 million in surplus funds. That barely covers the spending surplus in DHCF now for the Alliance. That we just one agency in the city. So if you're going to say we're going to take on additional costs, impossible to do, but then something has to be cut somewhere else. That's all I'm saying.
Oh, no, I disagree completely in the sense that we funded this based on the agency's estimates of what it would cost and that this will reduce costs because of the Medicaid match. Now, I understand that's at risk right now, but that is a separate conversation from what our policy should be, what laws have been passed, and whether or not this agency and the mayor are following the law.
I don't know how I can say any clearer that if the council would like this bill considered on its merits, they simply have to submit language that
We
is
don't want
legally
it
sufficient.
considered on its merits. We want it implemented because it's the law. I'm not going to change wording and then hope and pray that Mayor Bowser has a change of heart and decides to implement the SPA. That is why we put the shall.
That is your prerogative, and the mayor's prerogative is also if she chooses to not violate the law.
I don't have any further questions, Madam Chair.